Call on Government Order of the Day number 5.
Criminal Procedure Legislation Bill, first reading.
Call the Honourable Chester Borrows.
Thank you, Mr Speaker. I move the Criminal Procedure Legislation Bill now be read a first time. I nominate the Justice and Electoral Committee to consider the Criminal Procedure Legislation Bill. There has been a growing criticism of criminal procedure in New Zealand in the last few decades. It has been described as an impenetrable maze. It has been plagued by excessive delays and unnecessary hearings, and costs have been mounting. The Criminal Procedure Act 2011 and its 14 associated amendment acts passed in October last year modernised and simplified criminal procedure. In fact, they represented the biggest reform and modernisation of criminal justice procedure in nearly 2 generations. These acts consolidated criminal procedure law and introduced a comprehensive package of reforms to make the criminal justice system more transparent, understandable and efficient. The reforms are expected to result in over 31,000 fewer court events per year. It is estimated that they will free up about 10,000 court sitting hours each year. The reforms have the potential to take up to 9 weeks off the average time of cases that go to jury trial. The overall reforms have the potential to increase the efficiency of the courts to the value of about $15 million over a 10-year period. A small number of provisions, including those relating to the name suppression and sentence indications provisions, came into effect on March 2012. However, the majority of legislation will commence in July 2013. Since the enactment, several technical issues have been identified in the Criminal Procedure Act and a small number of other acts. Some may criticise the government for needing to introduce this legislation, but as members will know, the bill giving rise to the Criminal Procedure Act and its associated acts was complex and well over 500 pages in length. There is a high degree of interrelationship between the relevant legislation. Given the sheer scale and scope of the legislation, some of the minor errors, while regrettable, are unsurprising. Further, the bill has amended at Select Committee and again at the Committee of the Whole to address concerns raised about aspects of the reforms. Some resulting minor cross-referencing and other technical deficiencies have been identified since enactment. The lead-in time from enactment of this legislation to its full commencement was provided for training and systems changes to implement the new criminal procedures. And it is in that context that the need for a number of these technical fixes has been identified. The amendments in this bill are of such a technical nature that they would normally be suitable for inclusion in the Statutes Amendment Bill. However, as the remainder of the 2011 criminal procedure legislation is intended to commence on the 1st of July 2013, these amendments must be in place by that date. This year's SAB is not guaranteed to be enacted by that date, which necessitates the standalone bill. The amendments fall largely into 6 categories. First, there are some purely technical drafting and cross-referencing errors in the Act, for example, incorrect section references. Second, in a small number of instances, the bill enhances certain procedural provisions to ensure that they will be fully implemented and to operate as intended. Examples include the Clause 6 amendment relating to the period to file a summons and the Clause 7 amendments relating to the ability of a prosecutor to join charges without the court's leave. Third, the regulation-making powers in the Criminal Procedure Act are extended so that terminology and procedures and other legislation can be aligned with those of the Criminal Procedure Act by regulations. This will reduce the need for the House to devote its time to unnecessarily considering minor technical amendments. Fourth, there are amendments to the Criminal Procedure Act to give effect to the intent that community magistrates have jurisdiction to receive guilty pleas for certain offences for which they will have sentencing jurisdiction. Fifth, other legislation will be amended to align with the terminology and procedures of the Criminal Procedure Act. And finally, a small number of enactments are amended to replace references to the term crime where it is required. Currently, crime is defined in the Crimes Act 1961 as an offence where an offender is proceeded against by indictment. The criminal, soft on crime, that's right. Soft on crime and the definitions of crime, let's put it that way. The Criminal Procedure Act replaces indictments with charging documents. She's away. With charging documents, and offences are categorised by penalty level rather than how they are proceeded against. Accordingly, upon commencement, the definition of a crime will be repealed. Greens will vote for it, no doubt. Several acts contain references to a crime. For example, the Crimes Act 1961. It is an offence without lawful authority or excuse to have one's face covered or disguised with intent to commit a crime. The bill makes a small number of amendments to a few acts to replace the term crime with a reference to the most appropriate offence type in the context of each act. In the case of a person having their face covered or being disguised, the reference to a crime is replaced with a reference to an imprisonable offence. This will align with a change already made in the criminal procedure reforms to the burglary offence. This bill is not contentious. It is a technical, non-controversial piece of legislation. It will clarify and give full effect to legislation that this House has already approved. It will ensure that the largest criminal procedure reforms in 50 years can be implemented effectively and coherently, and that the benefits predicted are fully realised. The amendments will enhance operational efficiency. This legislation will provide greater clarity for Defence Counsel, prosecutors and judiciary, who will be required to apply the legislation. On that basis, I expect the bill will receive wide support from all parties, and I commend the bill to the House.
The question is that the motion be agreed to. Call Charles Cheval.
Thank you, Mr. Speaker. Mr. Speaker, the